5 seconds to go. Start. Hence, the degree of proof required in such a proceeding before the JJ board when an application is filed seeking a claim of juvenility when the trial is before the concerned criminal court is higher than when an inquiry is made by a court before which the case regarding the commission of the offence is pending. That when a claim for juvenility is raised, the burden is on the person raising the claim to satisfy the court to discharge the initial burden. However, the documents mentioned in Rule 12.3 A1, 2 and 3 of the JJ Rules 2007 made under the JJ Act 2000 or subsection 2 of section 94 of JJ Act 2015 shall be sufficient for prima facie satisfaction of the court. On the basis of the aforesaid documents, a presumption of juvenility may be raised. The said presumption is, however, not conclusive proof of the age of juvenility, and the same may be rebutted by contra evidence let in by the opposite side. That the procedure of an inquiry by a court is not the same thing as declaring the age of the person as a juvenile sought before the JJ board when the case is pending for trial before the concerned criminal court. In case of an inquiry, the court records a prima facie conclusion, but when there is a determination of age as per subsection 2 of section 94 of 2015 Act, a declaration is made on the basis of evidence. Also, the age recorded by the JJ board shall be deemed to be the true age of the person brought before it. Thus, the standard of proof in an inquiry is different from that required in a proceeding where the determination and declaration of the age of a person has to be made on the basis of evidence scrutinized and accepted only if worthy of such acceptance. That it is neither feasible nor desirable to lay down an abstract formula to determine the age of a person. It has to be on the basis of the material on record and on appreciation of evidence adduced by the parties in each case. This court has observed that a hyper-technical approach should not be adopted when evidence is adduced on behalf of the accused in support of the plea that he was a juvenile. If two views are possible on the same evidence, the court should lean in favor of holding the accused to be a juvenile in borderline cases. This is in order to ensure that the benefit of the JJ Act 2015 is made applicable to the juvenile in conflict with law. At the same time, the court should ensure that the JJ Act 2015 is not misused by persons to escape punishment after having committed serious offences. That when the determination of age is on the basis of evidence such as school records, it is necessary that the same would have to be considered as per section 35 of the Indian Evidence Act inasmuch as any public or official document maintained in the discharge of official duty would have greater credibility than private documents. Any document which is in consonance with public documents, such as matriculation certificate, could be accepted by the court or the JJ board provided such public document is credible and authentic as per the provisions of the Indian Evidence Act, which section 35 and other provisions. Ossification test cannot be the sole criterion for age determination, and a mechanical view regarding the age of a person cannot be adopted solely on the basis of medical opinion by radiological examination. Such evidence is not conclusive evidence but only a very useful guiding factor to be considered in the absence of documents mentioned in section 94(2) of the JJ Act 2015. Rishi Pal Singh Solanki Supra is under the Act 2015. With a view to compare section 48 of the Act 2013 with section 94 of the Act 2015, we may also reproduce herein below section 94 of the Act 2015, where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provisions of this Act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record such observation stating the age of the child as nearly as may be, and proceed with the inquiry under section 14 or section 36 as the case may be, without waiting for further confirmation of the age. In case the committee or the board has reasonable grounds for doubt regarding whether the person brought before it is a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board if available, and in the absence thereof, the birth certificate given by a corporation or a municipal authority or a panchayat, and only in the absence of first and second above, age shall be determined by an ossification test or any other latest medical age determination test conducted on the orders of the committee or the board. Stop.